Now, a violation is defined as any failure to comply with an administrative simplification provision, including HIPAA and HITECH. The Department of Health and Human Services categorizes privacy violations into 4 categories. 1, did not know. 2, reasonable cause. 3, willful neglect that has been corrected. And 4, willful neglect that has not been corrected. A civil money penalty, or CMP, is the amount of money assessed by the government that a covered entity may have to pay as a result of a violation. Now, each category has a CMP range associated with the type and a cap of 1.5 for violations of identical provisions within the same calendar year. Now, as a result of HITECH, clarification was made that non-compliance can result also in criminal penalties, including prison. Criminal penalties can apply to any individual, including employees. Depending on the type of compliance issue, penalties range from $50K to $250K and from 1 to 10 years in prison. So there are 3 types of policies that POs must implement and enforce. You've got corporate, you've got state, and you've got facility. So corporate privacy policies, including the corresponding state-specific versions of the corporate policies, must be implemented as is. The facility model policies are adopted locally on the facility letterhead and may be customized to include operational or state requirements, as we discussed earlier. We will cover facility, state, and model policies in Module 2, so please come back for that for your to finish up your training. We're also going to cover breach risk assessments and notifications in Module 2. So let's take a closer look at corporate privacy policies. The Facilities Privacy Program is led by the PO. The program must balance the business needs and the uses of PHI with the privacy rights afforded to the patients by the HIPAA privacy rule. Facilities must implement the corporate privacy policies as well as develop and implement facility-specific privacy policies. In addition, the facilities and states with additional or more restrictive requirements must develop and implement the state-specific requirements and ensure that the most current versions of the corporate policies are implemented as well. In addition to implementation of privacy policies and procedures, POs must assure compliance with the policies. Previous versions of the revised policies and procedures must be retained for a minimum of 6 years. Very important, 6 years. Now, education is a very important aspect of the privacy program. All members of the facilities workforce must have job-specific and facility-specific privacy training. The training must cover HIPAA privacy, HITECH, and company and facility-specific policies and procedures. This would, one thing, when you have new workforce members come in, you want to ensure that this privacy training occurs within 30 to 45 days. While the HIPAA privacy rule does not specifically require annual refresher privacy training, POs are strongly encouraged to provide refresher training on a regular basis, such as annually, and make sure to maintain your documentation for at least 6 years. Now, as we've discussed, a privacy officer is responsible for the oversight and implementation of the company's and facilities privacy program and works to facilitate compliance with HIPAA privacy standards, HITECH, and privacy policies. The privacy officer assists with the communication and implementation of the privacy program to the facility's workforce. In addition, the privacy officer plays a major role in developing, revising, communicating, and documenting privacy policies and procedures. All POs must be informed of all privacy complaints and OCR investigations. The PO is responsible for advising members of the workforce on privacy matters as appropriate. In addition, POs must participate in the mitigation of the harmful effects of inappropriate access, use, and/or disclosures of PHI that violate the HIPAA, HITECH, and privacy policies and procedures, and ensuring that appropriate sanctions are applied in accordance with your policy. We'll discuss more about breach mitigation, privacy complaints, and employee sanctions in Module 2, so make sure you come back for that. So let's check our knowledge. When must training on privacy policies occur for new workforce members? Training for new workforce members must occur within a reasonable time frame, typically 30 to 45 days. And again, the training must be job-specific and facility-specific. The HIPAA compliant authorization is not required for a facility's own payment, treatment, and limited healthcare operation activities. An individual may revoke an authorization in writing except to the extent that the facility has taken action in reliance thereon, or if an authorization was obtained as a condition of obtaining insurance coverage. For example, if the facility has already made the disclosure described in the authorization at the time the patient revokes it, the patient may only revoke authorization for additional or future disclosures. In the event an individual revokes a permissible compounded authorization as permitted for multiple research projects, unless there is clarity from the individual on which specific component or components the individual is revoking, the entire authorization will be considered revoked. You may refer to this slide for a list of the elements that must be included for an authorization to be valid and HIPAA compliant.